Hey everybody. So we also had, after Charles Babcock's letter to the court, we had a letter from Kevin Fritz on behalf of Wayfarer, which responded to Blake Lively's. How did I describe it? I felt it was an opposition to the motion for judgment on the pleadings, but dressed up as a request for an extension of time. So my opinion was, as technically she did oppose that motion, she asked the judge to deny it, and she gave a cause for denying it, in this case, untimely. And I think Wayfarer do feel the same. And they filed a letter, short response, just addressing some of the points. One thing that Wayfarer do not address in this letter, which Lively raised in her letter, her response to the motion, Wayfarer do not address the claim by Lively that she amended her CRD to include It Ends With Us movie. So that is not addressed in this letter, and we are no further forward with an answer as to, did she do it? If she did, when did she do it? Were Wayfarer aware of that, etc.? All the questions that we have, we still have no answers for. So I wanted to just put that caveat out there. And I have no more information or answers to give, unfortunately, on that. But we may hear about it because we got the hearing on this matter at 2 p.m. Eastern. That is 7 p.m. tonight for me in the UK. But I will be calling in and listening, and then I will do a video summarizing afterwards. But for now, we have this letter, so let's see. They make some really good arguments, actually, and it's incredibly, I felt that the words on the pages of Lively's letters were almost yelling. And they come across as a very angry letter. Whereas here, Kevin Fritz is just, I don't know, written like the most chill letter ever, but makes his point extremely well. So here we go. Dear Judge Lyman, as counsel for Wayfarer Studios, Justin Baldoni, Jamie Heath, Steve Sarowitz, It Ends With Us Movie, Melissa Nathan, The Agency Group PR, and Jennifer Abel, collectively the Wayfarer parties, we write in response to the letters dated 30th of September 2025 from Blake Lively concerning the Wayfarers parties' motion for judgment on the pleadings and the deadline for service of request to admit. So yes, Blake Lively, I haven't done a video on that. Blake Lively also subsequently filed a request to extend the deadline for services of request to admit. They are going to briefly address that as well in this letter. So they start out by rebutting Lively's gripe, if you will, that the motion for judgment on the pleadings was untimely, and say it's timely. Rule 12C permits a party to move for judgment on the pleadings after the pleadings are closed, but early enough not to delay trial. Pursuant to Rule 12H2, a challenge to a plaintiff's failure to state a claim is not waived until the close of trial. So, there is no hard and fast time limit on a Rule 12C motion under Rule 12H2. And I agree with this next point. I love that they're making it. Miss Lively erroneously argues that the Wayfarer parties sat on their motion for nearly 9 months, and that adjudicating the motion now would only lead to duplicative briefing and waste judicial resources. First, Miss Lively's operative pleading was not filed 9 months ago, but 2 months ago. And that's really important. She's trying to she's trying to say that basically this that Wayfarer were aware of this when she filed her lawsuit 9 months ago, like her first complaint. Not a first amended, not a second amended, but the actual initial complaint she filed. She's trying to say, well, they've known about it since then, but that's irrelevant because you have to brief. You've got to brief everything. And she filed her second amended complaint on the 30th of July. And then Wayfarer had to then file answers. That's where the briefing is complete. So it was a bit disingenuous for her to suggest that they've just sat on this for 9 months when that is not true. And I'm really glad they've responded to that. In response to the court's dismissal of her claims against Judd Wallace and Street Relations, Miss Lively was not obligated to amend her pleadings, but nonetheless chose to file her second amended complaint on July 30th, 2025. When Miss Lively opted to supersede her earlier pleadings with the filing of the second amended complaint on July 30th, 2025, she knew that the Wayfarer parties were not obligated to file answers thereto for several weeks thereafter, and that upon such filing, and only upon such filing, the Wayfarer parties were entitled to move for a judgment on her pleadings. Indeed, as Miss Lively recognises, at a July 30th, 2025 hearing in a related proceeding, the Wayfarer parties notified the court that they may seek relief under Rule 12C. If Miss Lively is now unprepared to oppose the motion, the fault lies with her. And it does. Second, the motion will reduce briefing on any subsequent dispositive motion and preserve judicial resources. In contending that the question at this stage of the case is not what the pleadings allege, but what the evidence shows, Miss Lively misconstrues the standard of review on a 12C motion. A judgment on the pleadings is appropriate where, with all reasonable inferences drawn in favour of the non-moving party has failed to allege facts that would give rise to a plausible claim or defence. Here, the motion seeks dismissal based upon purely or predominantly legal issues. 1. Miss Lively's claims for sexual harassment, retaliation, failure to supervise, and aiding and abetting under California statutes fail for lack of extraterritorial application. 2. Miss Lively failed to exhaust her administrative remedies with respect to various claims against It Ends With Us movie. And that's all they say about it. 3. Miss Lively fails to adequately allege retaliation. 4. Miss Lively's defamation claims are barred by the litigation and or fair reporting privileges. And 5. Miss Lively failed to allege an underlying tort supporting her civil conspiracy claim. None of those issues require the court to examine anything other than Miss Lively's second amended complaint and the materials incorporated therein by reference or integral thereto. Tellingly, Miss Lively does not specify how any of the voluminous evidence she has uncovered would be properly considered in opposition to the motion or warrant the denial thereof. Stated differently, there is no need for Miss Lively to scramble to amass evidence from ongoing discovery to oppose the motion, because the motion challenges defects on the face of her own pleadings. Although Miss Lively notes that she may yet again amend her pleadings, she does not explain why she has not done so or why the court should allow any such amendment at this stage of the litigation. And that's important because she can't just opt to amend her complaint. She would have to seek leave from the court to do that. If the motion is granted in full or in part, any such adjudication will reduce the number of Miss Lively's claims. In turn, and even assuming any party subsequently seeks summary judgment, the case will have been properly streamlined, thereby reducing the amount of briefing and evidentiary submissions on any such motion. Thus, judicial resources will be preserved for the very purpose of a Rule 12c motion. Third, Miss Lively does not and cannot explain how the adjudication of the motion will delay the trial scheduled to commence on March 9th, 2026. Fact discovery is ongoing, no summary judgment motions have been filed, and the trial is more than 5 months away. Courts have granted Rule 12c motions at procedural stages that are much more advanced than in this case. In the alternative to her request for dismissal of the motion, Ms. Lively asked for an extension of time from October 10th, 2025 to October 27th, 2025 to formally oppose the motion. Ms. Lively seeks the extension for the reasons given above, which appears to be that the discovery is still ongoing. The court may recall that while discovery was ongoing, the Wayfarer parties were compelled to oppose dispositive motions as well as numerous motions for sanctions against the Wayfarer parties and their counsel filed by Miss Lively and her husband Ryan Reynolds. And that's very true. Additionally, granting Miss Lively's judgment would mean that the parties would be briefing the motion close in time to the summary judgment deadline, before the court has had a chance to narrow the case. The request should be denied. On September 9th, 2025, the court revised the expert discovery schedule to provide for the completion of such discovery by November 14th, 2025. However, the parties did not propose, and the court did not endorse an adjournment of the current November 5th, 2025 deadline for summary judgment motions. As it stands, summary judgment motions are due before expert discovery may be completed. Accordingly, and given that certain fact discovery has not yet been completed but is expected to be completed by October 10th, 2025, last night the Wayfarer parties proposed the following revisions to the case management plan and scheduling order and are awaiting a response from Ms. Lively. Okay, so they've pitched these deadlines to Lively's legal team and they're still waiting for a response at the time of recording this. So they are proposing a deadline to exchange opening expert reports of October 24th, a deadline to exchange expert rebuttal reports of November 7th, a deadline to complete depositions of experts of December 1st, and a deadline to file summary judgment motions of December 15th. Okay. Good cause exists to amend the scheduling order. And then they cite the Fairy Puppet Studio case, that Lyman's case, that always gets put into every request for schedule amendments or extension of times. The proposed schedule will provide the court with sufficient time to resolve the motion, give the parties the opportunity to finish fact discovery prior to exchanging opening expert reports, and allow the parties to complete expert discovery prior to the filing of summary judgment motions. Most importantly, if the majority of Miss Lively's claims are dismissed via the motion, The proposed schedule will allow parties and the court to focus on her few remaining claims in connection with any summary judgment motions and/or trial. Moreover, on September 30th, 2025, merely 10 days before the current October 10, 2025 deadline for opening expert reports, Ms. Lively proffered a new theory of damages. Okay. So some redacted parts here. Whereas Ms. Lively's alleged lost profits computation was previously based upon, and then that's redacted. She has recently added redacted. So she's changed something. Something to do with her damages. Okay. The Wayfarer party's expert must now examine that claim. On February 3rd, 2025, the court directed in the case management plan and scheduling order that requests to admit shall be served by August 14th, 2025. In the parties' joint request to revise part of the scheduling order, no request was made to extend that deadline and no extension was ordered. Now, 8 months after learning the deadline and 6 weeks after the deadline has passed, Ms. Lively seeks to extend the expired deadline. However, Ms. Lively fails to explain why she did not serve request to admit by the deadline or why the existence of future depositions prevented her from serving requests, especially given that the purpose of the request to admit is to narrow factual issues. The request should be denied for failure to demonstrate good cause for the proposed amendment. That's a fair argument. She's been unreasonable, as always. Anyway, I will be doing a follow-up video later after the hearing with a summary of what was discussed, what was, if anything, agreed, etc., etc. So thank you for joining, and I will see you later on.